Hello, I am Amanda, Gen X Alaska. We are reading the Alaska State Constitution because I'm a nerd and I just want to know everything I can know about the great state of Alaska. We are on Article 5, Natural Resources, Leases. The legislature may provide for the leasing of and the issuance of permits for exploration of any part of the public domain or interest therein, subject to reasonable concurrent uses. Leases and permits shall provide, among other conditions, for payment by the party at fault for damage or injury arising from non-compliance with terms governing concurrent use, and for forfeiture in the event of breach of conditions, sales and grants. Subject to the provisions of this section, the legislature may provide for the sale or grant of state lands or interests therein, and establish sales procedures. All sales or grants shall contain such reservations to the state of all resources as may be required by Congress or the state, and shall provide for access to these resources. Reservation of access shall not unnecessarily impair the owner's use, prevent the control of trespass, or preclude compensation for damages. Public notice. No disposals or leases of state lands or interests therein shall be made without prior public notice and other safeguards of the public interest as may be prescribed by law. Mineral rights. Discovery and appropriation shall be the basis for establishing a right in those minerals reserved to the state which, upon the date of ratification of this Constitution by the people of Alaska, were subject to location under the federal mining laws. Prior discovery, location, and filing, as prescribed by law, shall establish a prior right to these minerals and also a prior right to permits, leases, and transferable licenses for their extraction. Continuation of these rights shall depend upon the performance of annual labor or the payment of fees, rents, or royalties, or upon other requirements as may be prescribed by law. Surface uses of land by a mineral claimant shall be limited to those necessary for the extraction or basic processing of the mineral deposits, or for both. Discovery and appropriation shall initiate a right, subject to further requirements of law, to patent of mineral lands if authorized by the state and not prohibited by Congress. The provisions of this section shall apply to all other minerals reserved to the state which by law are declared subject to appropriation. Mineral leases and permits. The legislature shall provide for the issuance, types and terms of leases for coal, oil, gas, oil shell, sodium, phosphate, potash, sulfur, pumice, and other minerals as may be prescribed by law. Leases and permits giving the exclusive right of exploration for these minerals for specific periods and areas, subject to reasonable concurrent exploration as to different classes of minerals may be authorized by law, like leases and permits giving the exclusive right of prospecting by geophysical, geochemical, and similar methods for all minerals may also be authorized by law. Water rights. All surface and subsurface waters reserved to the people for common use, except mineral and medicinal waters, are subject to appropriation. Priority of appropriation shall give prior right, except for public water supply. An appropriation of water shall be limited to stated purposes and subject to preferences among beneficial uses, concurrent or otherwise, as prescribed by law, and to the general reservation of fish and wildlife. Access to navigable waters. Free access to the navigable or public waters of the state, as defined by the legislature, shall not be denied any citizen of the United States or resident of the state, except that the legislature may, by general law, regulate and limit such access for other beneficial uses or public purposes. No exclusive right of fishery. No exclusive right or special privilege of fishery shall be created or authorized in the natural waters of the state. This section does not restrict the power of the state to limit entry into any fishery for purposes of resource conservation, to prevent economic distress among fishermen and those dependent upon them for a livelihood, and to promote the efficient development of aquaculture in the state. Amended 1972. Protection of rights. No person shall be involuntarily divested of his right to the use of waters, his interests in lands, or improvements affecting either, except for a superior beneficial use or public purpose, and then only with just compensation and by operation of law. Uniform application. Laws and regulations governing the use or disposal of natural resources shall apply equally to all persons similarly situated with reference to the subject matter and purposes to be served by the law or regulation. Private ways of necessity. Proceedings in eminent domain may be undertaken for private ways of necessity to permit essential access for extraction or utilization of resources. Just compensation shall be made for property taken or for resultant damages to other property rights. Article 9, Finance and Taxation. Taxing power. The power of taxation shall never be surrendered. This power shall not be suspended or contracted away except as provided in this article. Non-discrimination. The lands and other property belonging to citizens of the United States residing without the state I think that should say within, I don't know. Without the state shall never be taxed at a higher rate than the lands and other property belonging to the residents of the state. Assessment standards. Standards for appraisal of all property assessed by the state or its political subdivisions shall be prescribed by law. Exemptions. The real and personal property of the state or its political subdivisions shall be exempt from taxation under conditions and exceptions which may be provided by law. All or any portion of property used exclusively for non-profit religious, charitable, cemetery, or educational purposes, as defined by law, shall be exempt from taxation. Other exemptions of like or different kind may be granted by general law. All valid existing exemptions shall be retained until otherwise provided by law. Interests in government property. Private leaseholds, contracts, or interests in land or property owned or held by the United States, the state, or its political subdivisions shall be taxable to the extent of the interests. Public purpose. No tax shall be levied or appropriation of public money made or public property transferred, nor shall the public credit be used except for a public purpose. Dedicated funds. The proceeds of any state tax or license shall not be dedicated to any special purpose except as provided in Section 15 of this article, or when required by the federal government for state participation in federal programs. This provision shall not prohibit the continuance of any dedication for special purposes existing upon the date of ratification of this section by the people of Alaska, amended 1976. State debt. No state debt shall be contracted unless authorized by law for capital improvements or unless authorized by law for housing loans for veterans, and ratified by a majority of the qualified voters of the state who vote on the question. The state may, as provided by law and without ratification, for the purpose of repelling invasion, suppressing insurrection, defending the state in war, meeting natural disasters, or redeeming indebtedness outstanding at the time this Constitution becomes effected. Amended 1982. Local debts. No debt shall be contracted by any political subdivision of the state unless authorized for capital improvements by its governing body and ratified by a majority vote of those qualified to vote and voting on the question. Interim borrowing. The state and its political subdivisions may borrow money to meet appropriations for any fiscal year in anticipation of the collection of the revenues for that year, but all debt so contracted shall be paid before the end of the next fiscal year. Exemptions. The restrictions on contracting debt do not apply to debt incurred through the issuance of revenue bonds by a public enterprise or public corporation of the state or a political subdivision, when the only security is the revenues of the enterprise or corporation. The restrictions do not apply to indebtedness to be paid from special assessments on the benefited property, nor do they apply to refunding indebtedness of the state or its political subdivisions. Budget. The governor shall submit to the legislature at a time fixed by law a budget for the next fiscal year, setting forth all proposed expenditures and anticipated income of all departments, offices, and agencies of the state. The governor, at the same time, shall submit a general appropriation bill to authorize the proposed expenditures and a bill or bills covering recommendations in the budget for new or additional revenues. Expenditures. No money shall be withdrawn from the Treasury except in accordance with appropriations made by law. No obligation for the payment of money shall be incurred except as authorized by law. Unobligated appropriations outstanding at the end of the period of time specified by law shall be void. Legislative post-audit. The legislature shall appoint an auditor to serve at its pleasure. He shall be a certified public accountant. The auditor shall conduct post-audits as prescribed by law and shall report to the legislature and to the governor. And that is all for this portion. I am Amanda, Gen X Alaska. Join me in the next video as we continue reading the Constitution of the State of Alaska. And like always, you have to watch me walk off because I don't want to edit. Love ya.